If negotiation fails and we can't settle it, then we always talk to the other lawyer and see if we can't get them to agree to mediation. Both sides bring in a third-party mediator who assists the parties and their lawyers in coming to some common ground and reaching a settlement. Now, a lot of times my clients ask me, well, you know, you've tried negotiating with the other lawyer and it didn't work. Why should we go out and pay money to a mediator to have them come in and try to help y'all negotiate and settle the case? And the answer is, well, frankly, because lawyers aren't taught very well how to settle cases. Lawyers are taught how to fight cases, how to advocate for their clients. And that means that they're always talking, especially to the other side, about we've got this witness and we've got this case and we've got this argument and we're going to be able to win such and such, and the other lawyer's doing the same thing. And that's not very conducive to settling the case. When you bring in a third-party mediator to help you settle the case, that mediator, as a trained former judge or lawyer, him or herself, they can meet with the parties privately and say, okay, now, Mr. Plaintiff, what are the weak parts of your case? Well, we don't have any weak parts. Come on now, let's talk about the weak parts of your case. And same way with the other side. He meets with them in private and gets them to be realistic about the value of their case. And long and short of it is, the mediator tries to help them come together and resolve the case through a settlement. Arbitration is the same as a non-jury trial. They have a hearing. Very important aspect of arbitration is you hire an arbitrator. Both sides get together and they go through the list of arbitrators, lawyers or ex-judges, and say, let's pick so-and-so. What's different about that than the court system? Well, think about it. You're selecting your own judge, along with the other side, of course, but both of you are agreeing this arbitrator, we both know him and trust him. And therefore, you know that the result is going to be fair. They hear from the plaintiff's side what their evidence is. Witnesses come in and actually are sworn and testify just like they would in a courtroom. And then the defense puts on their case the same way. And an arbitrator then goes out and considers the evidence from both sides, hears the arguments from both sides, and makes a decision, just like a judge would do in a non-jury trial. Now, why is that a benefit? Lots of benefits to arbitration if it's done properly. With the expense that's built into the inherent delays in the court system, it's a lot cheaper, usually, to go to arbitration than it is to go to court. It's done privately, in a conference room, usually in the arbitrator's law office or some meeting room or down at the state bar headquarters or something of that. It's not public. Now, you're never going to get a runaway jury. Arbitrators have been in the courtroom for years, and they know what the value of a case is. You rarely see any home runs for plaintiffs in arbitrations, but you see a lot of doubles. And if I can get my client a double, and that's what the client is entitled to, an arbitration is the way to go. Point is, arbitration can be a very, very efficacious way to resolve a dispute if it can't be settled by negotiation or by mediation.